often a client will ask me whether he or she can retain the house in a divorce action or indeed a separation agreement. And the answer is depends. Depends on what? Well, it's a whole variety of factors. And one of the first things that I ask a client is, if you intend to take on the house and there's a borrowing over the house, in other words, a mortgage, you need to establish whether you are able to take on the borrowing in your own name. And often that's not the case, where the borrowing is at a particular level and the party who wants to keep it does not have enough income to meet the borrowing requirements. So that then changes the landscape hugely. But on other occasions, there are times where if you're receiving a capital sum, which might be in cash, you can reduce the borrowing and then take on the house if that's possible. But the first thing is, can you take on the borrowing? And from there we can work out what the capital division would be that would perhaps allow you to do that. But if you can't keep the house, that doesn't mean to say that your spouse or your partner might not let you stay there. And we have an agreement which would then reflect that you stay there with the children for a period of time to what I call a trigger date. For example, when the children leave school, or if you met somebody and lived with that person, something that was important, and then at that stage then you would consider either selling or transferring at that stage. There are ways around it.